Hi everyone. Today our video will be on the topic Waqf under Muslim law. Let's see what is the definition of Waqf. The literal meaning of Waqf is detention. It means a dedication in perpetuity of some specific property for some pious purpose. According to Abu Yusuf, Waqf is the detention of a thing in the implied ownership of Almighty God in such a manner that the Prophet may revert to or be able to the benefit of his creatures. So, naturally, when someone does Waqf of his property, the ownership will be transferred to God. In Moti Shah versus Abdul Ghaffar Khan, Waqf means the retention in the ownership of God in such a manner that its profits may be applied for the benefit of his servants. The object of dedication must be religious or charitable. This was the definition of Waqf held by the Honorable Supreme Court in Moti Shah versus Abdul Ghaffar Khan. Next, let us see what is the historical evolution of Waqf. Waqf traces its roots to the time of Prophet Muhammad, peace be upon him, and his companions, who encouraged acts of charity and endowment to support the Muslim community. We can see that Waqf has grown during the Islamic Golden Age too. During the Islamic Golden Age, Waqf flourished as rulers, scholars, and philanthropists endowed vast resources for charitable and religious purposes, leading to the establishment of mosques, schools, hospitals, and other institutions. Now, if we look at the medieval period, Waqf continued to play a central role in the development of urban infrastructure, social welfare, and religious institutions in the cities across the Muslim world, contributing to advancement in education, healthcare, and public amenities. In the Ottoman era, the renowned Ottoman Empire further institutionalized Waqf, establishing comprehensive legal framework and administrative structures to govern Waqf properties and ensure their effective management and utilization. Now, after that came the colonial influence. During the colonial period, it saw significant changes to Waqf administration, with colonial powers imposing new regulations and restrictions on Waqf properties, leading to challenges and controversies regarding their ownership and management. And in the today modern era of today, Waqf has faced challenges such as mismanagement, legal complexity, and funding constraints, prompting efforts to revitalize and modernize Waqf institutions through innovation in governance, finance, and technology. Today, Waqf continues to make a global impact with Waqf institutions and endowments supporting diverse charitable, educational, and social welfare initiatives in Muslim majority countries and Muslim communities worldwide. So, having had a look at the historical evolution of Waqf, let's see what are the essentials of Waqf. The first essential is a permanent dedication of any property. The second one, it must be by a person professing Muslim faith, and it must be for any purpose recognized by the Muslim law. In the case of N.R. Abdulaziz versus E. Sundaresha, the Madras High Court held that it is fundamental principle of Muslim law of Waqf that when a mosque is built and consecrated by public worship, it ceases to be the property of the builder and the property of right of property and ownership vests in the God. It cannot be reverted to the founder. Similarly, in Muhammad Qasim versus Muhammad Dastakir, the Supreme Court held that, according to Muhammadan jurists, the term Waqf literally means dedication by a person professing the Muslim faith of any property for any purpose recognized by Muslim law as religious, pious, or charitable. So once these essential ingredients of Waqf are satisfied, the ownership of this property, that is the Waqf property, is transferred from the person who is doing Waqf, that is the Waqif, to God, and it is irreversible. Now let's see what are the modes of creation of Waqf. Muslim law does not prescribe any law for creating of Waqf. It may be verbal or in writing. Let's see some modes which are usually relied upon. First one, by an act of inter vivos. What is an act of inter vivos? An act of inter vivos, also known as inter vivos, It is a transfer. It refers to a legal transfer or transfer of property that takes place between living persons. So, if there is a transfer of ownership or property between two living persons, it is known as inter vivos. In other words, it is a transfer of assets or property that occurs during the lifetime of the parties involved, as opposed to the testamentary transfer. Testamentary transfer is those transfer which occurs after the death, like inheritance or will, etc. In the context of Waqf, an act of interviews refers to the creation of Waqf during the lifetime of Waqif. The Waqif is the one who is donating, the donor of the property. So, what are the categories of act of intervivos in the context of Waqf? That is, it is declaration, Waqf deed, transfer of possession, and oral declaration. Let's see it one by one in detail. Declaration, it is also called as Ahd. Waqf can be created through a simple declaration, Ahd, by the Waqif, that is the donor of the property, where they express their intention to dedicate assets or properties for specific religious, charitable, and philanthropic purposes. Next is oral declaration, Iqrar. It is also an act of inter vivos. In some cases, Waqf may be created through an oral declaration. It is also called Iqrar by the Waqif in the presence of witnesses, where they express their intention to dedicate certain assets or properties for Waqf purposes. Writing, that is, it is also modes of creation which comes under interviews. It is also called as khat in Arabic. Waqf can be created through a written document, khat, prepared by the waqif, known as the waqf deed, waqafiyya. The waqf deed is also called waqafiyya, which formalizes the terms, conditions, objectives of the waqf, providing legal recognition and clarity. Next is transfer of possession. That is also an act of inter vivos, modes of creation of waqf. It is also called as iqda. Waqf may also be established through the transfer of possession, iqda, of assets or properties by the waqif to the waqf, symbolizing their dedication for waqf purposes and ensuring their utilization for designated beneficiaries. Dedication in perpetuity, Habs al Mal. Waqf is typically created with the intention of perpetual benefit, ensuring that the endowed assets or properties remain inalienable and are utilized for the designated purposes indefinitely in accordance with Islamic principles. So, these are the forms by which Waqf is created by an act of intervivos. Now, coming to by will, this will is also called wasiya. Waqf can also be established through will, that is wasiya, wherein the waqif, it is the owner of the waqf property, includes provisions for the creation of waqf in their testamentary disposition. We have already said that testamentary disposition means after the death or like inheritance and all, outlining the terms and conditions and objectives of the endowment. Now coming to the next slide. Revocation of Waqf. How is Waqf revoked? If a valid Waqf has been created, it cannot be revoked by the Waqif, for it is in the power to divest God of his ownership of the property. So we have already seen that when Waqf is created, when a valid Waqf is created, the ownership transfers from the Waqif, that is the donor of the property, to God, and it is irreversible. Thus, a testamentary may be revoked by the author of the Waqf before his death. So if it is inter vivos, it is already transferred, that is by oral, written, or other modes of interviews we have already seen in the previous slide. It is irrevocable, it is non-transferable once it is done. But in case of testamentary, that we have already said that it takes place after it comes into effect after the death of the donor or waqif. In case of testamentary, it may be revoked by the author of the waqf before his death. A waqf during the death illness without consent of the heirs is valid only to the extent of one third of the property and invalid beyond this limit. This is a vast topic, which is also called equitable one third. That is, only one third can be given for Waqf if it is of inheritance property, and without the consent of their heirs, the other two-third can't be given for Waqf. A Waqf created by inter vivos is irrevocable if the Waqf reserves the power of revocation. We have already seen that. Now, coming to the next slide, kinds of Waqf. Waqf khairi or public Waqf. Public waqf are those which are dedicated to the public at large, having no restriction of any kind regarding its use. For example, bridges, wells, roads, etc. comes under this public waqf or waqf al-khairi. This type of waqf is created for the benefit of the Muslim community at large or any section thereof, whether residing in India or outside India, or for the benefit of all mankind. Waqf Khairi aims to serve charitable, religious, or philanthropic purposes, such as the construction and maintenance of mosques, schools, hospitals, orphanages, and other social welfare institutions. Now, the second sort of Waqf is private Waqf or Waqf Ahli. Those which are for the benefit of private individual or class of individuals may be which may be settlers family, is called private waqf. It is only for the benefit of those people it is reserved for. It is established for the benefit of the settler or waqif or their family members, including descendants and relatives. It may involve provisions for the maintenance, education, welfare, or other need of the settler's family members. Now, finally, Waqf Khas. Waqf Khas refers to any Waqf that does not fall under the categories of Waqf Khairi or Waqf Ahli, that is, private Waqf or public Waqf. It encompasses Waqf endowments established for specific purposes or beneficiaries not covered by the other types of Waqf. Examples include Waqf properties dedicated to the maintenance of a particular mosque, cemetery, shrine, or religious institutions. We'll be looking at the salient features of the Waqf Act 2013. As per this law, Waqf has been defined in such a way that it shall be a Waqf regardless of the endower being a Muslim or non-Muslim, and that it would be a Waqf for all legal purpose. So in the essentials of Waqf, we saw that it must be a Muslim person who is giving the Waqf property. But in Waqf Act 2013, it says that both Muslims and non-Muslims can endow his or her property for Waqf. If the survey has not been done in each state, it should be completed. The survey should be completed within a year so that no property remains unregistered. It is incumbent on the revenue department officials to finalize land records. These are some of the salient features which govern the provisions of Waqf Act 2013. From Section 32, the power of the board to sell, exchange, or mortgage or to gift has been done away with. The tenure for the lease of the property has been fixed to 30 years now so that the Waqf property be developed. The Waqf tribunal shall now be tri-member, including an Islamic scholar, apart from the judge and the representative of the administration. Their scope has also been widened. The very much disputed Section 87 has been removed. The new act has strengthened the Central Waqf Council and widened the scope, and to an extent, the State Waqf Board are now answerable to the Central Waqf Council. So these are the latest amendment to the Waqf Act, what changes had come. And next is constituents of Waqf. Some of the important terms, we'll be dealing with some important terms in the context of Waqf. The first one is Waqif. We have already seen the meaning of Waqif. It is the donor. The Waqif is the individual or entity who the Waqif is the individual or entity who initiates the Waqif by dedicating assets or properties for specific religious, charitable, or philanthropic purposes. It can be an individual or entity. Next is Waqf property. The assets or properties endowed by the Waqf constitute the Waqf property, which becomes inalienable and is intended to serve designated purpose in perpetuity. That is, it is forever. It cannot be. It is not revocable. It is irrevocable. Next is objectives or maqasid. The objectives or purposes for which Waqf is established reflect the values and priorities of the Waqf, ranging from supporting education, healthcare, and social welfare to promoting religious practices and community development. Next is trustee or mutawalli. This is a very important concept. The mutawalli or trustee is responsible for managing and administering the Waqf property in accordance with the Waqf's intention and Islamic principles, ensuring transparency, accountability, and effective utilization of funds. Perpetuity. A defining characteristic of Waqf is its perpetual nature, with the benefits accruing to the successive generations, ensuring the continuity of charitable activities and the sustainable impact of Waqf endowments over time. And finally, Sharia compliance. Waqf operates within the framework of Islamic law. Islamic law is what is called Sharia, adhering to principles of charity, justice, and ethical conduct to ensure that its establishment, management, and utilization are in accordance with Islamic teachings and objectives. So, having have looked at the constituents of Waqf, we said that Mutawalli is a very important topic. Let's see What is important about Mutawalli? Mutawalli is a person who manages the Waqf. We have already said that in the previous slide. He has no right to transfer Waqf property to anyone. He is just the administrator. So the ownership and possessory right is with God after Waqf is completed. This person just manages the property and runs it. According to the Waqf Act 1954, a Mutawalli is a person appointed either verbally or under any Waqf deed or instrument or by the state Waqf board. Either it will be given in the Waqf deed who will be the Mutawalli, or it is decided by the state Waqf board, or it is decided through some other instrument, legally enforceable instrument. Any person or committee managing or administering any Waqf property is also a Mutawalli as per the Act. All matters relating to the appointment, powers, functions, etc. of the Mutawalli are governed by the Waqf Act of 1954. In the case of Ahmad Arif versus Wealth Tax Commissioner, the Supreme Court held that Mutawalli has no power to sell, mortgage, or lease Waqf property without prior permission of the court or unless that power is explicitly provided to the Mutawalli in Waqfnama. Waqfnama is the deed, the legally enforceable document of Waqf. Now, coming to the next slide, powers and duties of Mutawalli. Being a manager of the property, he has the following powers and duties. First one, to take all reasonable actions in good faith. He should have good intention in whatever action he does. The second one is to protect the interest of the Waqif. Waqif is the donor of the property, the Waqf property. His interest must be protected and it should adhere to Islamic rules. To discharge all the public dues and carry out all the necessary acts which are lawfully required. Fourth one is to carry out the directions of the board in accordance with the Waqf Act or any rule or order. Today, it is the Waqf Act 1954 with 2013 amendment that governs the rules and regulations of Waqf in India. So, Mutawalli has a duty to carry out his actions and management of the Waqf property in compliance with that rules. And finally, to furnish such returns and supply such information which is needed by the board in accordance with the provisions of the Waqf Act. Now, how is the removal of Mutawalli taking place? First one, what are the grounds with which a Mutawalli can be removed? First one, if he is convicted by a criminal court, he can be removed from his position. Second one is if he misappropriates the work of property. And finally, if he is of unsound mind and he is not capable of carrying out the duties which he is vested upon. Now, coming to the next slide, finally, we have reached the conclusion. In the conclusion part, we'll see the potential benefits of Waqf. First one is empowering communities. Waqf serves as a vital tool for community empowerment, enabling sustainable development initiatives and social welfare programs. Second one is economic stability. Leveraging Waqf assets can contribute to economic stability by generating revenue streams for charitable causes and infrastructure projects. Preservation of heritage is another advantage of Waqf. It plays a crucial role in preserving cultural and historical heritage through the maintenance and restoration of Waqf properties. Collaborative efforts, encouraging partnership between governments, NGOs, and private sectors entities can maximize the impact of can maximize can maximize the impact of Waqf initiatives and foster inclusive growth. Sustainable future is also a potential positive of Waqf. By embracing innovative strategies and modern government frameworks, we can ensure that the longevity and relevance of Waqfs in shaping a more equitable society. And last but not the least, let us unite our commitment to unlock the full potential of Waqf, harnessing its transformative power for the betterment of humanity. That is all for today. Thank you.